Hello, and welcome to California Gun Law. I'm your host, Don Hammond. Today, I'm going to talk about Assembly Bill 1078, which would fix a problem with Senate Bill 2's presumptive disqualification criteria for getting a California CCW license. I'm a licensed California attorney and shooting instructor. I regularly help teach the 16-hour class that's required to get a concealed carry license in California. On this program, we provide education on California's complicated web of gun laws so that responsible gun owners can better understand how to lawfully exercise their rights. California has a complicated web of firearm laws and regulations, and there are lots of traps for the unwary. We want to help you do it right so you won't need our criminal defense legal services. So getting to today's topic, Assembly Bill 1078 was introduced in the California State Legislature on February 20th, 2025. It would close off one controversial way that issuing agencies deny CCW licenses, temporary restraining orders, or TROs. Before we get into how this new law would do that, we'll need some background. It used to be really hard to get a CCW license in many California counties because the applicant would need to show good cause for needing a license and good moral character, whatever that means. These requirements have been removed over the last few years, so now it's actually pretty easy for most people to get a CCW license in California. Back in 2022, a United States Supreme Court case called Bruin v. New York State Rifle and Pistol Association eliminated the good cause requirement. The case was regarding a New York law, but immediately became the law of the land, which abrogated California's good cause requirement as well. At that point, California still had a good moral character requirement, which was very subjective, and it was the most common reason for CCW license denials. That all changed when the legislature passed Senate Bill 2 in 2023. Of course, it took effect January 1st of 2024. Senate Bill 2 was the California State Legislature's response to the Bruin decision. It actually opened up the CCW landscape, eliminated the good moral character requirement, and made California a shall-issue state. Senate Bill 2 took effect on January 1st of 2024. If you meet the conditions of the statute, then issuing agencies no longer have discretion to deny a CCW license. However, there's a list of disqualifying factors in Penal Code Section 26202. One of these disqualifying factors is being subject to a restraining order within the last 5 years before submitting the application. So that means that if the restraining order expired less than 5 years prior to submitting your application, you're sunk before you even started. A problem with the way that 26202A3 is written is that it draws no distinction between permanent orders issued after a hearing and after a judge hears evidence versus temporary orders that are issued ex parte, without notice or a hearing. Issuing agencies and judges hearing CCW denial challenges under Penal Code Section 26206 have been interpreting the law broadly to deny people CCW licenses even if the restraining order was just temporary, with no notice, no hearing, and no due process. We call this a TRO. They're commonly issued immediately when someone applies for a restraining order. Judges give them out like candy. It's pretty heavy to deny someone a constitutional right without at least giving them notice and a hearing, a chance to respond to the allegations and have a judge make a ruling about them. After all, in Rahimi, the United States Supreme Court held that someone subject to a restraining order could be temporarily denied their Second Amendment rights if a judge found at a hearing that they were dangerous. A key part of the court's decision in Rahimi was that he was given notice and a hearing. I was successful in one Penal Code Section 26206 hearing regarding a temporary restraining order. Penal Code Section 26206 sets up the hearing process to have a judge review a CCW license denial. In this case where I was successful, my client had not even been served with a temporary restraining order, and the petitioner actually withdrew the petition for the restraining order prior to the hearing. I argued that my client had not been subject to the order because a TRO is not enforceable until it is served on the restrained party. So since my client was never served, It wasn't enforceable against him, therefore he wasn't subject to the order. So I convinced the judge to order the sheriff's department to issue my client his CCW license despite the TRO that had only been gone for about 2 years. Assembly Bill 1078 would fix this issue. It would amend Section 26202A3 to only disqualify people who were subject to an order after hearing. It would add an exemption for cases where the order expired or was vacated or otherwise canceled and the applicant did not receive notice and an opportunity to be heard before the order was issued. This means that a TRO that was issued without a hearing and was either not served or was canceled before the judge made a decision at the hearing would no longer be a bar to getting a California CCW license. In many cases, restraining order cases are resolved with an informal agreement, so the judge never issues an order after hearing. People in these cases should be clear if this law takes effect. I've had some clients whom this change would really help, and it makes sense. Why would we deny a constitutional right to someone because of an untested allegation? People can say anything in a restraining order application and get the judge to order a temporary restraining order, which then would prohibit somebody from a Second Amendment right for 5 years. They should at least have a chance to be heard if they're going to lose their Second Amendment right to have a CCW license for 5 years. But watch out for the catch-all in Section 26202A1 that a CCW license can be denied if the applicant is reasonably likely to be a danger to self, others, or the community at large. In fact, the new bill, AB1078, requires issuing agencies to review the California Restraining and Protective Order system for information indicating that the applicant may be reasonably likely to be a danger to self, others, or the community at large, and it refers back to subdivision A1. It remains to be seen what factual issues may lead to a denial based on what the agency sees in that system. In general, we have not seen issuing agencies abusing that reasonably likely to be a danger language in 26202A1. Assembly Bill 1078 was just introduced in the legislature on February 20th, 2025, 3 days before I'm shooting this video, so it'll be a while before any action is taken on it. It may be amended during the process, and this version that we're talking about is likely not to be the final version. So it's a step in the right direction for the Second Amendment and for CCW applicants in California. We'll try to post future updates as this law makes its way through the legislature so that you can stay up to date. So stay up to date, stay legal, and stay safe. I'm Don Hammond at California Gun Law, and we'll catch y'all next time.